everybody, Excited Utterance here. My name's Hella, and I have my friend Andrea here. I assure you, she did giggle when she saw the little bobblehead of her as Wonder Woman. And I hope that brightened up her morning. She saw it very first thing this morning. So her morning, it was late my last night. And I got that because a lot of people in her chat were calling her Wonder Woman and Superwoman and all sorts of things. My goodness, this lady has been burning the midnight oil, and that isn't even starting to explain the kind of work that she has been doing. Andrea Burkhart, lady, dear me, after this thing is over, surely you're going to have a holiday. Surely. Now, if you don't know this lady, to my right, she is a defense attorney and appellate attorney from Washington. She has given up 6 weeks of her life to go travel to Indiana and sit in a courtroom all day, every day, even Saturdays, to witness the trial of Richard Allen, Indiana versus Richard Allen, for the murder of two girls, Libby and Abby, and they were murdered in 2017. And the reason she's doing that is because the judge in the case, Judge Gull, has closed off the proceedings to all audio and all cameras. So that means that only 20 seats are available to the public. Those seats are hotly contested. The people who are able to access those seats basically have to wait in line every single day, even in the cold at night, in order to get those seats. We have line sitters who are kindly giving up their time. They have their little fold-out chairs and things, and they are taking turns to sit in line so that people like Andrea, there are some other YouTubers as well, who are sitting, waiting for their turn to get their seats so that they can report for us what's happening in that courtroom. And I tell you what is happening in that courtroom is worth reporting. So Andrea has gone a step further, and apart from all of that time she's spending in the courtroom and all the time that she is spending at night, and I tell you what, it's 5 hours lately she's been reporting to us at night. If you're not watching her streams at nighttime, you are missing out. 5 hours of detailed reporting she's providing for us. It's like watching the court. After that, in her spare time, she is writing to the Supreme Court to get them to intervene into Judge Gull's orders to not allow us to see what's going on. How's that? So she has now written it's not a writ of mandamus. The writ of mandamus is what the Supreme Court would do to intervene. So it is a petition for a writ of mandamus. So first, what I'm going to do is say hi to everybody. So bobblehead Andrea is amazing. Thank you. It gets people's attention. Jeff liked it. Jeff said that something about it having big thighs. I was like, sorry. He was joking. Happy 1st of November. What's the 2nd of November, young? Rachel says hi. Andrea and True Crime Something both do amazing work. True Crime Something. I really hope she takes a nice vacation. Me too. 27 seats open to the public. I think it was 20, but maybe there's 27. Andrea said that at the moment what's happening is because the state's case has rested, there are slightly less people showing interest, especially people are starting to leave around lunchtime, which is kind of interesting. Did I hear the news, Hella? What, Justin? I don't trust you. What's the news? What's the news? Jeff! Hello! good to see you, man. You called them thunder thighs. Dude. Well, it's just a bobblehead. And you know what I think we should do, Jeff? I think we should crowdfund to get an actual one of these made. Because you know you can, right? You can get a Wonder Woman likeness of Andrea bobblehead actually made. I know, because David's got one. David's got like a little Superman bobblehead of him. I think he ordered it himself. How lame is that? Maybe his colleagues ordered it. I don't know, but he loves it. We can get it made. I reckon we should all organize it. That would be so cool. And you can tell them to like change it a little bit. Maybe we can make the thinner thighs for you. Welcome, Jeff. Good to see you. Sarah's guilty. Oh, is that your news, Justin? Thank you for that. All right. Hey, Factual Lie. How are you? Good to have you in chat, Jeff. All right. So, and Jeff's been doing the work big time as well, modding that chat. And I know because I'm modding that chat, but Jeff is big time. He's there beginning to end every single stream. It's 5 hours per stream. Modding that chat is like, it's fun. It's nice. It's a great stream to be on, but it is intense. There are 10,000 people in that chat. And there are a lot of things to moderate. So I have never modded a chat that big. I've modded a lot of chats, but never one that big before. And with as many different opinions. So good on you, Jeff. Well done. Well, Andrea's thighs are perfect and I need to stop. They are perfect. They are perfect. Everything about Andrea is perfect. Okay, what I wanted to start with is I wanted to show a little clip of Andrea, and it's at one of her moments when she wasn't too happy. She was not too happy at this time, and that's fair enough. That's fair enough. And this is part of why I think that she has put so much time into writing this motion. So let's just have a quick look at that.
I'm horrified. I'm horrified. I'm appalled. I'm disgusted. I'm angry. And I'm particularly infuriated that the entire world did not get to see this.
Yeah. She's not a happy Andrea. No. You don't want to get in her way when she's mad. Is she lovely? All right. So what I wanted to just get across to you guys before we start reading her petition is, what is a writ of mandamus? I ain't a lawyer, but it's pretty easy to look these things up. So writ of mandamus, let's have a look on statecourtreport.org. So the word mandamus comes from the Latin to compel. Writ of mandamus in state courts. So mandamus is an old common law remedy that allows a court to order government officials to perform their public duties. When a public official fails to follow the law, it's important that those impacted have efficient recourse. Similarly, in appellate practice, mandamus is an important caveat to the final judgment rule because it allows appellate courts to correct clear errors by lower courts before they compound. In many scenarios, mandamus can reinforce the law by ensuring that responsible officials follow the law. So, therefore, if you feel that something has been ruled incorrectly by, say, a circuit court judge, you can go to the Supreme Court in your state and file a petition for a writ of mandamus, and they can intervene. There you go. While litigants have long used the writ of mandamus in these ways, heightened polarization and intense partisan battles for control of key institutions has accelerated its use in high-profile political cases. Indeed, today's political environment is combining with mandamus to bring state courts, especially state high courts, to the fore of many hotly contested issues. Here's a couple of examples. For example, litigants seeking to have former President Trump banned from the 2024 ballot have used the writ of mandamus to obtain state high court review. In July 2023, former President Trump petitioned the Georgia Supreme Court for a writ of mandamus, you might remember that, halting and limiting the work of the special grand jury investigation regarding possible 2020 election interference. So there's a famous one, you may remember. In August 2022, the North Carolina Supreme Court upheld a writ of mandamus requiring state officials to finance public education, notwithstanding legislation to the contrary. And another one in Wisconsin, a voter advocacy group sued the state electoral commission before the 2020 election, seeking a writ of mandamus requiring the commission to purge voter rolls. Recently in Florida, a prosecutor, Monique Worrell, petitioned the Florida Supreme Court for a writ of mandamus, vacating her suspension by Governor Ron DeSantis on the grounds that he violated the state constitution. And in Ohio, voters petitioned the state Supreme Court for a writ of mandamus requiring Ohio's Secretary of State and the Ohio Ballot Board to remove a reproductive rights amendment from the ballot on the theory that it violated the state's constitution's single subject requirement. So there you go. You can petition the state Supreme Court when you think that something has been perhaps constitutionally incorrectly ruled, or that you think that a government official, a state official, a judicial representative has not done their job correctly. So that brings us to Judge Gull. Do we think that perhaps she's overstepped the mark? Well, I think Andrea probably thinks so. And so this is what she's done. No further ado, Superwoman, or Wonder Woman, in her spare time, has done this. Hello, Christine. Thank you for being a member for 10 months. Appreciate you so much. And thank you, everyone, for being here. Okay, so in the Indiana Supreme Court, case number something or other, so I'm sure she would have filled this in, Andrea Burkhart, and she is going with her own, like, she's being herself, all right? So she's not a party to this. She is a citizen, concerned citizen, and she is doing this on her own. We have to just give her props, guys. Well done to Andrea that she's taking it on herself to do this as really a service to all of us. So thank you. Yeah, absolutely. Hey, Shavals, how are you? Okay, verified petition for writ of mandamus. In propria persona. In person. Richard Allen is currently standing trial in the Carroll County Circuit Court for the murders of Abigail Williams and Liberty German. This case has captured global attention and interest, with tens, if not hundreds of thousands of members of the public around the world praying for this trial to bring justice to Abigail Williams and Liberty German, as well as peace and closure to the families of the victims and the community of Delphi, Indiana. But in spite of this overwhelming public interest, and in contradiction to fundamental principles of transparency in court proceedings and accountability of government, the court has cloaked this process in secrecy from its inception. Today, this inexplicable hostility to the openness of criminal proceedings, a principle enshrined in the First Amendment to the U.S. Constitution, has culminated in the court's decision to improperly bar portions of the public from access to parts of the trial while providing privileged access to others, and to unlawfully deny public access to court records generated in the course of the trial under Indiana's Rules of Access to Court Records, ACR. Right, so interesting. So she's saying that there are perhaps exhibits that are allowed to be seen by some people and not allowed to be seen by other people. There, obviously, Judge Gull has decided that the proceedings are to be barred to the general public. Only certain people are allowed in, and very, very limited. If you break her rules in that courtroom, you are asked to leave, and they're very, very strict rules. It's kind of, from what it sounds like, it's a little bit of a, I hate to say, yeah, I don't want to call her names, but she's the queen bee. She's the queen bee, and I know that's how it works. Like, I know that the judge is the boss, but she's also supposed to allow people to see what's going on. She's not supposed to just, like, get angry if someone breathes or, like, bites their fingernails and go, okay, you're out. That's it, done. And you can't see anything more. Or find a reason why someone should be pushed out of the room. You see? So you'll say it for Hella. Yeah, I didn't want to say the word, but yeah. If you bring gum, you have to bring enough for everybody. Yeah. She's the boss, not the queen. Yeah, it's a bit like that. Hey, Badger Witness, how are you? All right. In his letter appointing Edmund Randolph as the first Attorney General of the United States, George Washington expressed his conviction that the due administration of justice is the firmest pillar of good government. This petition seeks to restore a small measure of transparency to the trial of Richard Allen as mandated by the ICAR, so the public can evaluate for itself the justice that is being administered in the Carroll County Circuit Court in this trial. Okay, so facts supporting the petition. 1. Trial in this case of State versus Richard W. Allen commenced on October 14th, 2024 in Allen County, Indiana. The evidentiary phase of trial commenced on October 18th, 2024 in Carroll County, Indiana. The Honourable Francis C. Gull is presiding. Record P11. Prior to trial, representatives of media organisations requested access to view the exhibits admitted in the course of trial. Judge Gull informed the media that the exhibits would not be made available for public viewing until after the trial concluded, or if Mr. Allen were convicted, after sentencing. Record P67. Now, you guys have watched a lot of trials. How often is that the case? Have you ever seen that? Ever? Well, I've noted it in Brian Kohberger. We can't see anything in that. I don't know if there's been any ruling that we're not going to see it throughout the entire trial. But we certainly haven't seen anything much leading up to trial, that's for sure. But when the trial actually happens, I wouldn't be half surprised if we don't see anything throughout it, the way things have gone. But leading up to trial, yeah, not seeing anything. During trial, you generally see stuff. Yeah. So this is weird. It reeks of, when you hide something, it's usually because you've got something to hide, right? Okay. Judge Gull subsequently reconsidered her decision and entered an order permitting members of the media to view the exhibits for 15 minutes at the conclusion of each trial day. The order makes no provision for any member of the public to view the exhibits under the same conditions as the media. Many of the exhibits are being published to the jury by providing individual copies, such that these exhibits are not displayed in the courtroom and cannot be viewed by trial attendees seated in the gallery. So that's Andrea. I didn't know that, actually. I didn't know that the media, so if you're actual media, like mainstream media, that you could see it, you could see the exhibits for 15 minutes. That's, until I read this, that was news to me. I didn't know that. So they can see it. I'm sure they can't take pictures of it or anything like that, because we'd see it then. It would all be out in the public. I have attended the trial each day as a member of the public. I am an attorney licensed in Washington and Oregon who provides legal commentary on a variety of internet platforms, and I've been covering and analysing the trial of Richard Allen. Although my coverage reaches tens of thousands of viewers, because I operate independently of traditional news media outlets, I do not qualify as media under Indiana law, record P10. See, this is stupid to me. Does she not have a media pass? They're obviously not. She's just a member of the public. Generally, you can get a media pass. Like, we got a media pass to the Murdoch evidentiary hearing back in January, in the 27th of January this year. So we got it through David's channel. David organised a media pass for someone to go in there for us. So if you apply for a media pass and you have like a YouTube channel, usually courts will allow it, but not this one, clearly. A lot of good that pass was, darling. Yeah. It didn't do much good for us. We didn't get much reporting out of it. But yeah, you can generally get a media pass. Like Steve Gosney was going to be our media pass at Sarah Boone, but then he moved and obviously got quite busy. Yep. Yeah, this is silly. 5. Public attendance at the trial is limited to 24 seats. There you go. 24. Because of the extensive public interest in the case, competition for the seats requires those who wish to attend to arrive the night before or early in the morning of the trial and camp in line on the courthouse steps. It's like a rock concert, guys. It's like a K-pop concert. I just went to one. Although you don't need to camp out for those. You just have to like wait for 6 hours on an internet line, which I did for my daughter because I love my daughter. Wow. Camping out in line for a trial. What is going on? Legit. What is going on? Camping out in line to report on a trial. It happened for Karen Reid, didn't it? Didn't it? Like, those people had to, because there were fights in line, remember? Between, the towel guy and Aiden. Yeah. It's so silly. Yeah, Johnny Depp trial deja vu. Yeah. It's just so silly. Because, I get, I say, so with the Johnny Depp trial and with Karen Reid, I get that there were so many YouTubers who wanted to be there that they had to sort of jostle to get their place in line because they just wanted to be there, to be the eyes on the ground, like, and see jury reaction, and their channel wanted to be the ones to have the coverage, right? But then again, you didn't have to be there to report on it. You didn't, like, it was being streamed. Whereas in this case, we need people like Andrea there. There's no other way of reporting on it. Like, otherwise we're stuck with mainstream media who are only just giving us little tiny snippets of it. That's all we're getting from them. And if you're only watching them, guys, I don't know if you've seen what they're reporting, but for example, I watched one of their reports the other day, and all they said was, today the state brought forth the confessions, and he confessed however many times. He confessed to the crime. He said, I did it. And I'm like, really? That's all you're going to say? What? Wow. Okay. What are we up to? One individual from the local community informed me that there are many locals who have been deeply affected by this crime who wish to attend, but are deterred from doing so by the crowds and the conditions that must be endured in order to gain access to the courtroom. See, that's no good. Accordingly, I sought to obtain copies of the audio recordings of the trial in the belief that allowing the public direct access to the record of proceedings will alleviate the necessity to attend the trial in order to be informed about what is transpiring, thus easing the chaos that is characterizing public trial attendance, restoring the dignity of the proceeding, and improving the local community's opportunity to attend in person. Record P 11, 12, 13, 14. I wonder how that worked out. Oh, hey, Ginny. How's it going? Is this a stream? No, David, it's a dream. I'm sorry for being mean to you yesterday, David, but I did put your link up. I take back what I said about you. Hey, Ginny. Dear. Okay. Yeah, I wonder how that went. Beginning on October 18, 2024, Judge Gull made the trial exhibits available for inspection by credentialed members of the media, attending the trial by placing them on a table in front of the jury box and inviting them into the well to view them. There's a well? A well? I clearly don't know what a well is. Oh, David. You're here to support me. That's sweet. What's a well? It's a thing you get water from. Why has she put the exhibits in the well? This Gull woman's weird. Is a box in trial? Is that box in... I don't know. A well is where you... I know a well is where you get water, but why would she put it there? Hey, Chloe. Hi, people. Between the crime and the judge, I don't like this case. Not sure how long I could... That's all right. Good to have you here, though. All right. But Andrea's trying to make it better. This is about media access, so it's not too nasty. Okay. So, on October 19, 2024, a member of the public attempted to view the exhibits on the same conditions as the media. Judge Gull refused to allow the individual to view the exhibits and ordered her to leave. Be gone! Be gone from my courtroom! You! How dare you try to view the royal exhibits? Be gone! You're stricken. In light of Judge Gull's actions, excluding the non-media individual from access to the exhibits, and because I am not media, within the meaning of the October 16, 2024 order, I became concerned that if I sought to view the exhibits, which, as court records, are presumptively available to the public for inspection and copying, I could be excluded from the courtroom entirely. Record P 1516. Yeah, Andrea, you could totally be thrown out. And imagine if she was thrown out. Then what? She'd have to, perch herself on the roof with a listening device. Because of my concerns about the local community's inability to attend the trial and the exclusion of some members of the public from viewing the exhibits that others are allowed to inspect, I filed a motion requesting 1, copies of the audio recordings of the trial pursuant to the Indiana Criminal Procedure Rule 5 and ACR 3, and 2, parity in access to the trial exhibits on the same terms and conditions as was being afforded to credentialed media members pursuant to ACR 2A, record PP 10 to 18. That sounds fair? 10. Judge Gull denied my motion. Denied! I'm sure she enjoyed denying that too. Do you think she likes Andrea? Denied. Judge Gull denied my motion the following day, I bet. I wonder how hard she thought about that. Oh, hello. Villainess Cupcake. That's a good name. Everyone, I made it to alive. Good to see you. Good to see you. Hey. Bet she loathes her and us waiting to pounce. Yeah. No, I reckon she's a fan. Hey, Benjamin. The well is the space between the judge's bench and the desks of the prosecutor and defense tables and jury box. Well, there you go. Thank you for that little bit of information. And Content Lasagna is here. Hello. Just checking in. Are you hungry? Try the Olive Garden today. What Olive Garden? Okay. See, you always make me hungry when you come in anyway, because you're a lasagna. Well. Yes, well. Okay. I just love it that she denied the motion the following day. Denied. I bring this petition requesting this honourable court to compel Judge Gull and the Carroll County Circuit Court to comply with the ACR and provide the requested copies of audio recordings and access to the trial exhibits. Yeah. Jurisdictional statements and original action standards. 12. This court has jurisdiction over this petition as an original action. See Indiana Original Action Rule 1A. 13. This application has been made expeditiously after the respondent's court's failure to act when it had a duty to do so became an issue. So what she's doing is she's saying that she's already tried the first round of remedy, right? Because when we looked at the definition of writ of mandamus, you have to try the first thing. You can't just go straight to petitioning the Supreme Court. You have to go first to the actual court. Like, you have to actually ask Judge Gull, and she's denied it. So you have to do that before you go to the second round, which is this, going to the Supreme Court. It's like going over her head, basically. All right. So the first remedy didn't work, so you're going to try the second remedy, which is this. The respondent court has failed to act when it had a duty to act by denying public access to the audio recordings of trial that constitute a publicly accessible court record, and by excluding ordinary members of the public from access to view the trial exhibits that has been granted to credentialed members of the news media. Contrary to the express provisions of the ACR, see State Ex Rel Commons v. Pera, 987 NE 2D 1074 1076, Indiana 2013. Writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. State Ex Rel Seal v. Madison Superior Court Number 3, 909 NE 2D 994 Indiana 2009. Note, writ of mandamus will issue where trial court has failed to perform a clear, absolute, and imperative duty imposed by law. Yes, so when they haven't done their job, then you must do the writ of mandamus. Or Matt Damon, as some people call it. Hey, FFS. Because the trial is ongoing, this is 15, because the trial is ongoing, each day that Judge Gull's orders remain in effect impose a continuing harm on the public's rights of access to the trial proceedings. Go, Andrea! Moreover, because my request for limited intervention was denied, I am not a party to the case and lack standing to appeal. C.E.G. Kelly versus State 11 any. And I wish Dali was here to read all these numbers out because I just get tongue-tied. And cases cited therein, observing that the state and the defendant are the only two parties with standing in a criminal sentencing proceeding, and noting serious doubts that the recipient of a restitution order has standing to appeal. I need coffee. Oh, man. Justin. Gull is harming me. I can't read your name when it's upside down, Sam Show, whatever it is. Hey, Steph. You've got family visiting, I know. Thanks for being here, man. Wasn't R.A. moved around due to change of venue? He was moved around between different institutions. But, I don't know about the courts, if that's what you mean. Yes, and there are still two defendants in YSL. Okay. Serious doubts that the recipient of the restitution order has standing to appeal, State versus Bergman. Holding that the Indiana State Police lacked standing to appeal an order of expungement as it was not a party to the criminal conviction. Did I miss a bit? Moreover, because my request for limited intervention was denied, I am not a party to the case and lacking standing to appeal. Yes, I did read that. And cases cited therein, and the defendant are the only two parties with standing in criminal sentencing proceeding, and noting serious doubts that the recipient of a restitution order has standing to appeal, State versus Bergman. Holding that the Indiana State Police lack standing to appeal an order. Oh, she's noting case law now. Okay. Consequently, the denial of this petition will result in extreme hardship to the rights of the public, and there is no adequate remedy available by appeal. Yeah, so how's the public going to get this trial back? They can't. There's just no way around it. Yeah, people tell me I'm upside down, but it's you. Okay, 16. Rule 2A of the Rules of Procedure for Original Actions contains a required condition precedent that the subject matter of the original action must be raised and ruled on by the trial court prior to the filing of the original action. This matter was brought to the trial court by motion. That was her motion, and the trial court ruled on the motion, making the issue ripe for this proceeding. Ripe. Grounds for writ of mandamus. Let's go. This is why you gotta do it, SC. Original actions provide extraordinary remedies. And will be issued only where the trial court has an absolute duty to act or refrain from acting. State ex rel Commons v. Para 987. Writs are appropriate for cases that strike at the heart of the public trust in the integrity of the judicial process. Yeah, I think the public's pretty much lost trust in this judicial process, don't you? And she's stating State ex rel Kurtz versus Delaware, Circuit Court number 5, 2009. This case meets these standards. 18. ACR 1 provides that the ACR governs access to public records and applies to everyone who creates a court record. Under ACR 3A, a court record includes a case record, and a case record is any document, information, data, or other item created, collected, received, or maintained by a court agency, or clerk of court in connection with a particular case under ACR 3B. 19. Indiana Rules of Criminal Procedure Rule 5. Every court exercising criminal jurisdiction in the state must arrange and provide for the electronic recording of stenographic reporting. Yes. Surely there is like someone taking the written records. Okay, of any and all oral evidence and testimony given in all cases and hearings, including both questions and answers, all rulings of the judge in respect to the admission and rejection of evidence and objections thereto, and any other oral matters occurring during the hearing and proceeding. If the court does not prepare a transcription of the proceeding, then the electronic recording is to be maintained as a court record for 55 years in felony cases such as Mr. Allen's prosecution for murder. I'm sure that's the case. 20. Under the combined effect of these rules, the electronic recording is a case record that is subject to public disclosure under the provisions of ACR. Yes, but when? 21. ACR 4A provides that court records are generally accessible to the public, and ACR 4B states that this rule of accessibility applies to all records regardless of format. ACR 4C permits the court to manage access to the audio recordings to prevent substantial interference with the resources or operations of the court, or to comply with rules of public broadcasting of court proceedings that are not applicable to this request, but specifically provides that this rule may not operate to deny any person access to a court record. But specifically provides that this rule may not operate to deny any person access to a court record. That's important. 22. Public access. Public access includes the right to both inspect and copy a court record under ACR 3F. Justin. Transcripts will exist but likely sealed. I don't know, darling. I wonder whether Judge Gull intends to allow it all to be available after it's done. Like let him be convicted and then let it out or not. I don't know. I think like is her top priority just to get him convicted? Because once he's convicted, like most appeals fail. Although no judge wants an appeal to be on their record, I suppose. But yeah, how does she keep it from? How does she keep like the whole transcript of the trial sealed? I've not heard of that. But goodness me, she's done a lot of things I haven't heard of. Providing a digital copy of the file as requested requires little to nothing more than dragging and dropping a file, ooh, burn, that has already been created onto a data storage medium. I have offered to provide at my own expense for that purpose, or onto a cloud-based storage medium such as Google Drive or Dropbox that can typically be accessed by establishing a free account. No substantial interference with the court's operations would result. Andrea's like, it doesn't even have to cost you anything, guys. I'll pay for it. You can't argue with that. We have a similar rule in Michigan, but it allows courts to keep audio and video recordings private. They just have to release the transcripts and other court filings if requested. See, this is the thing though, David. They're not even doing that. So transcripts and other court filings, they're not releasing anything. Like nothing. Now, that's what she's asking for, isn't it? Am I wrong? Transcripts, exhibits, it's just nothing. Like she's keeping everything. Maybe eventually, but she'll wait till attention dies down. I don't think attention's dying down. Like if things get put out there. Like, if this stuff gets released, the second it gets released, people are on it. They'll be like, oh, look, the Allen stuff is out. In the order denying the motion to intervene and for public access to court records, Judge Gull ignores the foregoing provisions and instead cites Indiana Trial Rule 74D, which is inapplicable on its face. Record P19, by express provision, the Indiana trial rules apply only to civil actions, not a criminal action, such as the case at issue. See Indiana Trial Rule 1. Except as otherwise provided, these rules govern the procedure and practice in all courts of the state of Indiana in all suits of civil nature. Okay. Under the express provisions of the ACR, Judge Gull has an absolute duty to provide a copy of the electronic records if doing so does not substantially interfere with the operation of the court. Under the proposed mechanism for providing the copies, the time and expense the copy requests imposes is trivial. Okay, so I can see Gull making some argument that it does interfere with the operation of the court somehow. Like, Andrea is saying, look, I'll provide my own USB disk. You can just use a Google account, a Dropbox, it's all free. Gull can come up with some argument that there's the jury sequestered, we have limited time, that would mean taking time out to gather all the information together. It's not just a matter of just dropping it somewhere. She could come up with some crap. Not that she has ever bothered to come up with any reason. Like, she always just denies things and doesn't come up with a reason. She just goes denied. So, but if it did come from a writ of mandamus, does a writ of mandamus, that just compels her to do something, right? Like, can she argue with that? I don't know. I don't think so. I think that just says do it. Do it. Or suffer, then cope. Okay. The ACR further establishes procedures governing the sealing of trial exhibits. Under ACR 7A, any exhibit to be excluded from public access must be accompanied by a separate written notice identifying the specific ground under Rule 5 for sealing the record. No such notices have been filed concerning the trial exhibits in this case. Yeah, see what I mean? She hasn't given any reasons for these things to be sealed. No. She has not done any of these notes. There's a procedure for sealing of trial exhibits. And Andrea has noted that no such notices have been filed concerning the trial exhibits in this case. Caught out, lady. I love this. This is great. Now do you think Judge Gull likes Ms. Andrea? I wonder if she's seen this yet. I wonder, do you reckon she's seen it yet? Because this is only filed like last night. Lol. Quote from Seed Nerd, Your Honor. Yeah, Rachel, I can see her saying she doesn't have the manpower to provide them. Yeah. This is funny and great and all the things. Indeed, Judge Gull has already permitted certain members of the public to view the exhibits at the end of each court day. But she has limited this access to credentialed members of the media, thereby creating a privileged class of individuals. Ooh, I like that. Who are receiving greater access to court records than others. Oh, it's a class system now. Oh, this is cool. Yeah. That's what she just said, Ginny. Problem is she's providing to the media already, but only for 15 minutes. And they can just view it for 15 minutes. They get their 15-minute window because they're special and they have their little special lanyards and stuff. So they get to go into the well and they get to view it for 15 minutes and then they have to go toddle off. But they're special. The special class of media. Yes, it's segregation, Justin. This is so weird. All persons are to have access to court records under ACR 2A. Nothing in the rules contemplates preferred access or excluding some members of the public from access that is being freely afforded to others. Having established a procedure for inspection of the trial court exhibits, Judge Gull has an absolute duty under ACR 2A to provide this same access to all members of the public who are present in the courtroom and wish to inspect them. Suffer. Yeah, the nobility, like the CNNs, and there's what's that one that's close by, WTHR, I think they're called, with I think that's their name, WTHR or WTRH or something. That's the local one. Please tell me Nancy Grace is not one of them. She's not like media, is she? Not that she's there at the end of the day anyway. She's not. She leaves at 10 a.m. And she only turned up once. Oh, guys. Wait. Hearsay for days on Sunday. Just wait. I have so much Nancy Grace shade. So much. It's going to be so great. Wait, she is? Is she real media? Would she have a real media pass? No. She would. But she's not there at the end of the day. But she doesn't have to be there at the end of the day. Surely, like her reporters, like her team, they'd have a media pass just for her. She's media. No way. Andrea shall smite Nancy Grace. Shall smite her. Wow. Oh, I have some serious shade for Nancy Grace. Like her ex posts, they've been trolled so hard. It's so great. Like usually her ex posts, they get all her little fan bots, but they've just been completely overtaken on this one. It's great. Yeah. Nancy Grace, thanks Chloe. Excited on this. Nancy Grace is media, but she used to be respected but lost her mind lately. She's still got a big following though, Chloe. Like there's still a lot of people who just eat up everything she says. So I know, like, it seems like from where we sit, it seems like she's lost a lot of respect, and she has a lot of people that are biting back at her, but there's still hundreds of thousands of people viewing her videos and just saying thank you so much for like standing up for victims. You're such a victim advocate, la la la. So yeah, it's going to take a lot to knock her off her perch. She's going to have to like get cancelled or something. And I don't like cancel culture, but I could probably put up with it a little bit just for her. Just for her. Oh dear. Okay, let's keep going. Although these requirements are clear and unambiguous and were brought to the attention of Judge Gull, she has refused to fulfill the obligations the rule imposes on her to provide the requested public access. Issuance of a writ of mandamus is appropriate and necessary to compel compliance with the ACR. Yep. Statement of precise relief sought. Okay, so she has to be really, really clear as to what she's asking for from the court. Relator respectfully, okay, so she's the relator. Andrea is the relator. Relators respectfully request that a permanent writ of mandamus be issued. 1. Mandating that Judge Gull and the Carroll County Circuit Court provide digital copies of the electronic recordings of the trial proceedings in the matter of State v. Richard Allen, Carroll County Circuit Court, cause number, and I'm not going to read that out. Oh yeah. 2. Mandating that Judge Gull and the Carroll County Circuit Court, say that really fast 5 times, provide equal access on comparable terms and conditions to view the exhibits admitted in the above referenced trial to all members of the public present in the courtroom at the time of the viewing. So what she's saying that all of those 15-minute slots that the media have had, people like Andrea who've been there every day should now get in arrears 15-minute slots to view everything that's happened. So day 1, day 2, day 3, day 4, all of those 15-minute slots with those pieces of evidence, they should now get time with all that stuff. I can't see that happening, but that'd be amazing. Hey, Zach Gallery! There's a scant scent of Skintella ensconced here. I can smell Zach Ellery anywhere. Nice to have you here, Zach. You know why Andrea has filed this? Oh, yeah. And just for a second, think about, like, how, like, this is very detailed and well written, clearly, well researched. How much skill and time this would have taken, and when did she do this? How? It blows my mind. Lady, how did you do this? Does she have like a second Andrea hidden in the cupboard? Okay. In the Indiana Supreme Court, case number something, well, hang on. What's going on? Okay, so this part, relator's brief in support of petition for writ of mandamus. So she now has to put the relator's brief down, and there is a table of contents. So introduction, background, grounds for writ of mandamus and prohibition, and conclusion. Right, so this part's a little bit different. So introduction. Since the day that State of Indiana first charged Richard Allen with murdering Abigail Williams and Liberty German more than 5 years earlier, hang on. This is the same as before. Oh no, it's not. Let me just check. It's similar, but not the same. This, I was reading this yesterday, and there are parts of it, there are parts of it that are doubled up from prior, but there are also parts of it that are new. Yeah, okay. I'm gonna read it through. Excuse it's often the case with legal documents that you get a little bit of double up, but that's fine. She needs to incorporate this relator's brief, so I'm going to just read this through for you guys. All right. So since the day that the State of Indiana first charged Richard Allen with murdering Abigail Williams and Liberty German more than 5 years earlier, the proceedings have been shrouded in secrecy. From the prosecutor's effort to seal the entire probable cause affidavit establishing his basis for charging Mr. Allen to the trial court's exclusion of dozens of documents from the publicly accessible chronological case summary until after an original action was filed challenging it. The lack of transparency afforded to this case has contributed to a lack of trust in the justice that is being administered in this criminal prosecution. Yeah, the wording's different there. And it's true, guys, isn't it? So when it comes down to it, people don't trust that justice is being done. And if you have a look at the chats out there, people are torn between whether or not this case that's being presented is actually about the evidence of him being there and him doing this crime, or whether he was just tortured. Right? So, and are we even being shown everything? Do we even know what's being put forward by the state is everything? And do we even know whether the defense is going to be allowed to put forth their defense? I want to have a little bit of a talk about it afterwards, only for maybe 10 minutes, but I'm really interested in your thoughts now that the state has rested. Okay. Now that Mr. Allen is standing trial, the public appetite for information about what is transpiring and the nature of the evidence against him is only growing. But because the trial court continues to exclude portions of the process from the public, access required by Indiana's Rules of Access to Court Records, ACR, direct information is limited to the few individuals who are able to obtain seating in the courtroom each day. And even those individuals who are enduring significant hardships to attend the trial are being excluded from viewing court records, to which access is being provided on a privileged basis only to credentialed members of the news media. The status quo is untenable, contrary to law, and is undermining the public's trust in the fairness of the trial. A writ is appropriate, and in this case badly needed, to restore public trust in the integrity of the judicial process. State ex rel Kurtz v. Delaware Circuit Court No. 5, Indiana, 2009. Factual background. Richard Allen is currently standing trial for the murders of Abigail Williams and Liberty German, record P11. The trial has garnered substantial public interest, but because the trial court has denied media requests to broadcast the proceedings, direct information is available to non-media individuals only if they are able to secure one of 24 seats in the courtroom, being made available for public, record P1011. This competition for access has created a chaotic environment outside of the courthouse the night before each trial day, as hopeful attendees line up overnight to try to obtain a seat. Kinda like a K-pop concert. In addition, those who are able to attend are kept in the dark. Kinda like at night. About portions of the trial process. Exhibits admitted at trial are often not displayed in court in matter that renders them visible to all of the audience members in attendance. The trial court has permitted credentialed members of the media to enter the well of the courtroom after each day's session to review that day's exhibits for 15 minutes at the conclusion of each trial day. But the trial court has barred ordinary members of the public for the same access, going as far as to order an individual who attempted to view the exhibits without media credentials to leave. You must leave. You do not have the credentials. That's how I imagine she talks. You do not have the credentials. You must leave. As a member of the public and an advocate for transparency and accessibility in court proceedings, I filed a motion requesting that the trial court provide copies of the electronic recording of the proceedings for each day of trial, and to permit members of the public in attendance at the trial to view the exhibits under the same conditions that have been afforded to the credentialed media. Trial court denied my motion without addressing the applicable provisions of the ACR and relying on a civil trial rule that is expressly inapplicable to this criminal trial. I wonder which one. Grounds for writ of mandamus. The access requested is not discretionary under the ACR, and the public's right to the access requested is clear and unequivocal. Moreover, there is no alternative avenue for relief besides this original action. As demonstrated below, a writ of mandamus is appropriate and should issue directing the trial court to provide the public access requested. Original access actions provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. Writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. Yes, so if they haven't done what they're supposed to do, that's only when there will be one of these writs. That's the only time. And they haven't done what they're supposed to do. So that's what's going to happen. Here, the trial court has an absolute duty to comply with the ACR in providing public access to court records that are not confidential. ACR 1A. This rule applies to everyone who creates a court record as defined in Rule 3A. ACR 4A, a court record, is available to the public except as provided in Rule 5, which establishes specific categories of records that are automatically exempt from disclosure, none of which applies to the subject request. Both the audio recordings of the trial and the admitted exhibits are court records. Court records are defined to include case records, which consist of any documents, information, data, or item created, collected, received, or maintained by a court agency, or clerk of court in connection with a particular case, ACR 3A-B. The electronic audio recordings in a criminal case are governed by Indiana Criminal Procedure Rule 5, which specifically defines them as court records required to be maintained for a specific number of years. Unlike Indiana Trial Rule 74D, which applies only to civil proceedings, the criminal rule do not restrict access to the electronic recordings to the parties to the case. See generally Criminal Procedure Rule 5, Indiana Trial Rule 1, defining the scope of trial rules as governing only civil actions. Right, so there are some that only, if you are having a civil case, there are some that apply only to the parties, and only the parties can receive the recordings and the transcripts. But in a criminal case, the public has the right to receive them. Similarly, the ACR specifically acknowledges trial exhibits to be court records and permits them to be excluded from public access only if they are tendered or admitted with a separate written notice identifying the applicable ground for exclusion from public access. See ACR 7A. Consequently, all of the materials requested are court records to which the public is entitled to access as a matter of law. Right, and if you remember previously, she stated that none of this stuff has the required notes on it that it would need to be put on there to seal them. Right, so there's no procedure has been adhered to seal them from the public. What's going on, guys? Like, what is going on? This woman is a judge, a special judge, apparently. With respect to the exhibits in particular, the trial court's procedure for allowing credentialed members of the media to inspect trial exhibits while excluding ordinary members of the public from the same access runs afoul of ACR 2A, which affords all persons the right to access court records as provided by the rule. Emphasis added. Yeah, so she's put it in bold. Bold! Having established a procedure to provide limited inspection of the trial exhibits, there is no basis for the trial court to exclude some members of the public from the access provided while granting privileged access rights to the press. Guys, I'm just going to ask you guys a question, right? Why do you think she's giving more access to the mainstream media or the credentialed media than to the public in the gallery? You answer whilst I finish reading this. Having established a procedure to provide limited inspection of the trial exhibits, there is no basis for the trial court to exclude some members of the public from access provided while granting privileged access rights to the press. It has generally been held that the First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. Noting that the First Amendment right of access to criminal trials is a right held by the public, not the media. Because both the electronic audio recordings and the trial exhibits are court records, they must be subject to public access. Public access means that they both must be available for inspection and copying. ACR 3F, concerning the electronic recordings, the trial court's erroneous reliance on Trial Rule 74D is in direct conflict with ACR 4D, which prohibits the court from interpreting its court management authority to deny public access to electronic recordings. While the court does have some authority under ACR 4D to manage without denying, that's important, without denying public access so as not to substantially interfere with court operations or resources, the proposed access, providing a thumb drive to the court upon which to copy the electronic file or receiving a copy of the electronic file through a cloud-based digital storage service such as Google Drive or Dropbox that offers free accounts, is calculated to impose the minimum burden possible on the court while simultaneously permitting public access to the records. It's a duck. The media never tells the whole story. Yeah. Because they're biased to guilt. Yeah. Yeah, see, I think she doesn't want YouTubers there, and it's a control thing because she's already been in trouble. Yeah. Yeah. So the news media, I think they're safer for her. I think they're safer for her because, yeah, they tend to report in little snippets. You get, if you tune into any of the news media, they don't do like long form reports like Andrea does. Like any of the true crime channels, they do these sort of deep dives, right? And they're more likely to give more of an insight into the actual testimony that happened throughout the day. They'll talk about how the jury reacted. They'll talk about actually what was said and the feeling in the courtroom, and they'll try and give a more emotive sort of view. They may even err towards a defense mindset. The mainstream media tend to give more bite-sized chunks, and bite-sized chunks tend to just, they can't help but be more prosecution focused because, like I said, I just watched one the other day, and all they did was they said what the state's points were, and that was they came forth with the confessions, and he confessed 60-something times. And he said, I did it. And he told his wife, no, they're not messing with me. I really did it. Can I tell you now I did it? And he had a bullet there at the scene. And they just like have dot points on the screen, dot point, dot point, dot point, dot point. And they're the biggest things of the day. So I'll be interested to see what they do when the well, now that the defense is on, if there's any change in that, but I doubt it. I've seen these things roll out before, and they don't tend to show much. Even if they do show things that are from the defense's side, they then counter that with, oh, but on redirects, this, and this. So they don't show a full picture because they are doing a news report, and a news report usually goes for 3 minutes. So I think that's probably why she's kind of okay with the mainstream media being there. And she has to give someone access. She can't give no one access. The public's right and the trial court's duty are clearly established by black letter law. I don't know what black letter law is. Does that mean like the letter of the law? I know that term, the letter of the law. Can someone look that up for me? That'd be cool. Yeah, the letter of the law means not the spirit of the law, but the clear definition of the law as it's written. So I think that's probably what that means, but I've not heard that term before. Moreover, there is no adequate remedy besides the writ requested because there is no appellate remedy for the public in a criminal case due to the lack of standing. Yeah, the public can't appeal. The letter of the law is law. Is that lawful law? And cases cited therein, observing that the state and the defendant are the only two parties with standing in a criminal sentencing proceeding, and noting serious doubts that the recipient of a restitution order has standing to appeal. State versus Bergman 558/1990. Holding that the Indiana State Police lacked standing to appeal an order of expungement as it was not a party to the criminal conviction. Fair enough. Consequently, this original action provides the exclusive mechanism to correct the trial court's error and vindicate the right of the public to inspect the administration of justice in its courts as provided for in the ACRs. Conclusion. That's it. To restore the public's right of access to non-confidential court records, a writ of mandamus directing the trial court to provide the requested materials is appropriate and necessary. Respectfully submitted, Andrea Burkhart in propria persona. There you go. Wow. Wow. Even with Carl Rittenhouse, the MSM was calling him a white supremacist. Seeing the YouTubers show the videos they took of the night and racket streaming the trial exposed it all. Yeah, and he was found not guilty. I'm just going to Google, what was it? Black letter law? Black letter law. Black letter law is a term used in, it's a term used in common law legal systems to describe well-established legal rules that are considered indisputable and no longer subject to reasonable debate. Okay. It is also known as Hornbrook law or Trite law. Black letter law is the foundation of the rule of law in Australia and is made up of legislation and case law. Yeah, I've always thought that was called the letter of the law, but black letter law, fine. Cool. Okay, so guys, this woman, how does she do that oh my God, look at that beautiful L. Sorry, I'm into typography. Look at that beautiful L, everybody. Oh, look at that beautiful L. Sorry, go back to here. How did this woman do that in that much time? Ah, dear. Not everyone knows about Karen Read. how did this woman do this in this much time? And I would like to know, how long did it take the Indiana Supreme Court to action something like this? Because we've only got a couple weeks left. We've only got a couple weeks left. It's not long, right? So damage is being done now. Like, as she said, the damage is happening right now. Like, if they're going to action this, they have to action it now. Because people are missing out on the trial as we speak. People are missing out on this information now. And people like Andrea could get thrown out any moment. In fact, I think when Gull gets her eyes on this thing, she's going to get a look at Andrea, and if she scratches her head the wrong way, she could get thrown out. I'm really concerned about that. I really hope that's not the case, but I've been concerned about that for a while, that she could be in the firing line, because, I mean, why wouldn't she be? She's gone and put a motion in herself already, which has been denied. And now here she goes and puts this this motion to the Supreme Court. And question is, how can we protect Andrea? I don't know if there's a way any of us can do that. The worry is Andrea. I was trying to figure it out for a while. Yeah, it's really, I am concerned because I really think that Gull is going to be on her now. Why wouldn't she be? Needs security guards. It was like when she was streaming yesterday, and I know it was Halloween for you guys, because Halloween was 2 days ago for me. It was Halloween for you guys. And yeah, when she was streaming yesterday, there was a knock at her door, at her hotel door, and like boom, 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 and she was like, I can't answer right now. I was like, what the hell's that? But it was like 9:30 p.m. her time. Like, how could that be trick-or-treaters at 9:30 p.m.? Hopefully it was just like some hotel thing. Yeah. Those judges are given too much power lately. It's corrupting decent people. This woman has far too much power, because, like, how is she just denying motions without explaining? Usually judges, when they deny something, they give a reason, right? But this woman is just like, denied. What's with that? What is with that? Also, I would just like to ask, and I don't know whether or not anyone knows, because I've been asleep. Does anyone know if anything has come in today from the defense case regarding Odinism or not? Has anyone seen any reports? And I'd just like to ask people if they think at this point whether or not, you don't think so, Darlie? I've been thinking about this. Considering the state's case so far, I have a feeling that the Odinism thing might confuse the jury. I actually think that maybe they shouldn't bring it up. I was lying in bed and I was thinking about it. I was thinking about where the state's case was left, and I thought about this whole story about the crime scene and the guards and this whole Odinism thing, and I thought, do they need it? Does the defense need it now? I wonder if they were to leave it out and just go with disproving the bullet or casting doubt on the bullet, casting doubt on the identification, and then showing flat out that he was tortured, those confessions aren't real, is that enough? I think it's enough. Like, do it. Bring in all the Odinism stuff, like, as true as it is, bringing it all in, is that just going to muddy everything up and make them look a little bit like, I hate to say it, but kind of desperate to come up with a, like, pointing the finger at somebody else can sometimes backfire? What do you guys think? You don't know about this? Yeah, well, I mean, Judge Gull actually was going to, well, she did say that they couldn't bring in this theory. And Alan's defense team fought really hard to have her allow them to bring this in. But the crime scene was it was very weird. The way the bodies were laid out, the way there were sticks placed on the bodies, they were placed in such a way that looked like runes. There were also marks on a tree placed above one of the girls, marks that looked like an Odinist symbols. And then, more weirdly than that, there were guards in the jail prison who were taunting him, who had Odinist patches on their uniforms. And then when he was moved, there was another guard who was told to take away his Odinist patch, and then he went and got an Odinist tattoo on his face. It's all very creepy and strange. There's a lot of people implicated who are supposedly are part of some Odin cult. And there's a very strong case for it. The defense put forth a really detailed document about it about a year ago, actually, September last year. At first, people thought it was crazy. But then when they really looked into this research that had been done, and then saw these continually what was happening with the guards, it seemed to be too many things happening at once for it to not be true. But now I'm just wondering whether or not the state's case is so weak that if the defense brings in this stuff about this cult, if it undermines a little bit what the jury has seen, that they're probably I think they could be on board already with the fact he was tortured and that the confessions aren't real and everything else is quite flimsy. So I don't know. I think a psychiatrist, bullet expert, and FBI agent should be enough, unless they can get a former guard or inmate to testify. Yeah, and there is one former guard, actually police officer, I think, who didn't go with their theory and could testify for the defense. But yeah, I'm feeling really weird about it at the moment. I'm just wondering. I'm hoping that the defense strategy doesn't ruin it right now, because going down that path, it just worries me that the jury may end up clouded and confused, and it could be smooth sailing from here on in. That's just where I'm sitting right now. Can I have a look at the poll? Where are we? Look at the poll. And poll. Okay, so the poll says not guilty 67%, not sure 23%, guilty 9%. Ah, very good. Okay. Yeah. Well, it's interesting. Like, it really, it depends, guys. There are so many conflicting views right now. There are chats out there that are so guilty, guilty, guilty. You would be surprised. You'd be surprised. So make sure that you're with us for Hearsay for Days on Sunday. I'm going to show you some of the contrasting views that are out there. And I'm also going to show you Ms. Coffinduffer being completely felted by a fake set of Google searches that she fell for on her live stream. And she thought they were real, and she went and tried to investigate them. It was hilarious. My God. It was better than the drunk stream. Yup, it was very good. Yup. I had to give props to R&M Productions, actually. R&M Productions. This dude put these Google searches up on Twitter, and Coffinduffer bought it hook, line, and sinker. It was too good. It was too good. Oh, dear. Alrighty, that's it. Coffin Smacker is horrible. Oh, wow. She bought it, and she was like, oh, I think I can look into this. Dear me. Dear. Okay, so I'm just going to redirect us over to Andrea's stream. She's probably, don't think she's started yet. If she has, wow. But no, I don't think she started yet. But I'll just chuck you into her waiting chat. And yeah, I'll see you over in her chat later. I'll probably be modding over there for a few hours today. It's my Saturday though. So I'll see how long I last before I have to take my daughter somewhere. But yeah, thank you all for being here. And let's hope the Supreme Court does something about this situation before it's all over. Or does something at all. Even looks at it. And big claps to this lady. Thank you, Andrea. And thank you for trusting me to help you out. And I can't wait to have you on this channel at some point. Definitely. Oh, she is live. Okay, great. Cool. I'll see you over there, guys. Thank you. And I will just play the song and we'll be out. Oh, she's early.
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Donnie and she dances sometimes. The words are always so loud and because she's an 803.
Oh, hi, Laura.